Hearing examiner this evening. The purpose of this hearing is to allow me to receive evidence and testimony on the matters that are pending. I make a recommendation only to the Board of County Commissioners. I do not make the final decision. I will be submitting my recommendation to staff within 2 weeks of this evening's hearing. The application will then be scheduled for deliberations before the County Commissioners. If you wish to give testimony, I need you to fill out one of the sheets in the back. And when you come to the podium, please give your name and address for the record before you begin your testimony. In the case of the two zoning cases, first staff will introduce the application, then we will hear from the applicant. After the applicant's testimony, we will then get into the public comment sheets. We will hear from those who are in favor, those who are neutral, and then those who are opposed. The public not speaking will be read into the record. We will then give the applicant and/or their representative an opportunity for rebuttal of any testimony stated into the record from the public before we close the public hearing. After that point, we will receive no more testimony. The time limits are 30 minutes for the applicant's presentation, 5 minutes for public testimony, and 15 minutes for applicant rebuttal. I would ask that you direct all of your testimony to me and not to the audience. Are there any questions regarding these proceedings? And we'll talk about the procedure we'll use for the appeal when we get to that case. Okay, then we shall start with case number ZON 20-0013.
Madam Hearing Examiner, while we are waiting for Vlad to pull up the PowerPoint, I should just mention that all of our Zoom participants I have purposely muted for now until it's the appropriate time to ask them if they'd like to respond.
Good, thank you.
Good evening, Madam Hearing Examiner, for the record, Vlad Finkel with Kootenai County Community Development. Before I introduce the case, I'd like to disclose that I will strictly adhere to the facts of the case and the process.
Is it possible to turn up the sound so we can hear?
I don't know. Is it that you can't hear me or you can't hear Vlad?
Can you hear me?
There we go.
Okay.
I don't know if the microphones are not working or they're just.
I think his just went on.
Okay, sounds good. Once again, for the record, Vlad Finkel with Kootenai County Community Development. I will present this case.
Having a little feedback right now.
But Nancy will have to explain why that's occurring.
I think the feedback is I've turned it up so now it's going in the microphones.
Oh. So you've got it as loud as it will go.
You can try turning that one off and try the boundary mic if you want.
Why don't we? Yeah, that works.
Oh.
Just for everyone's information, we have an entirely new audio visual system. We are still working through the bugs.
Thank you, David. Once again, Vlad Finkel, for the record, I am planner assigned to this case.
We still have a hearing issue.
Okay, is this better? So I will introduce the case and speak about the specifics of the request. If there are any issues or any concerns that are raised by the hearing examiner that relate to the details of the request and I'm not privy to those, I will defer to the applicant's representative to further explain when it's their turn to speak. As you stated, this is a request, case number ZON 20-0013, a request to rezone a 5-acre parcel of land from rural to commercial with a conditional zoning development agreement by Silver Beach Properties LLC. The subject parcel of land is located on the north side of the county, specifically north of Spirit Lake, and it's a secondary lot north of Spirit Lake Road. As you can see, the aerial photo shows that the site is heavily vegetated. Based on the site visit conducted by staff last month, a majority of the site has been cleared of trees, and the applicant is ready to move forward with the development of that site, should the rezone be approved. The property is located kitty corner from an existing commercial resort that has been in operation for a number of years. It includes a component of a small marina as well as an RV park and then some open space area for recreation. The subject parcel is zoned rural, and it's surrounded by large tracts of land to the north and west and east that are zoned rural as well. Those parcels are undeveloped with some challenging topography. The parcel to the southwest is zoned commercial, and it's owned by the applicant of this rezone. Parcels to the south are zoned restricted residential, and there are a number of parcels that are smaller in size along the waterfront with larger tracts further to the north. The subject property is zoned border designation, and typically the comp plan states that a border designation is for limited scope of development where it could easily be annexed by the city that is in the immediate area. Here are some additional photos of the property in question. It's relatively flat, and it has been recently logged, and then the topography slopes uphill, heading north towards the city limits of Spirit Lake. The property is located within the Spirit Lake area of city impact. Now, what the code says is that we as a county, are obligated to give the county, or to give the city, time to respond with any concerns with regard to the proposed scope of the request. In this case, the comments from the Spirit Lake official came back with no concerns or no opposition. Excuse me. Just a second, we're having technical issues with.
You want the next slide?
Sure.
I can't get it either. I'm gonna try backing out of screen sharing and starting over.
Sure.
I don't know what else to do, frankly.
I can just go on with my PowerPoint. Just a second. Through the agency comment period, we solicited comments from Lakes Highway District, Panhandle Health District, City of Spirit Lake, Kootenai County Building Division, and Spirit Lake Fire. Here are some photos of the subject site. As you can see, this is where the proposed location of the RV park will be. The purpose of this rezone is to be able to relocate an existing RV park that is located on the waterfront parcel that is currently zoned commercial. The applicant has submitted a conditional zoning development agreement to limit the scope of future development of this 5-acre piece in order to address some of the concerns that were raised through the review process. As you may know, a standard rezone from one zoning classification to another zoning classification allows all outright permitted uses in that zone. It doesn't put any limitations on the future scope of proposed uses. The purpose of a zoning development agreement is to put specific sideboards and limitations on the future use of the site, because as you know, a rezone cannot be conditioned. So the only way to condition it is with a separate document that's recorded against the property, and it puts specific limitations. So the applicant did put together a document that would allow them to relocate the existing RV park from a waterfront parcel that's zoned commercial to this new parcel that would be a secondary lot. And they understand that the health department has not evaluated the property for the specific limitations on a future sewage system. So what the applicant has stated is they have a caveat in their conditional zoning development agreement that basically states, we will attempt to develop this site to the maximum of 48 RV parking stalls as we have on the commercial site that's waterfront. However, if we're not able to do so, then we will decrease the number of parking spaces to meet the requirements of Panhandle Health District. So, the Lakes Highway District official came back and they have concluded that based on the trip generation analysis that the applicant has submitted by Whipple Engineering, the overall number of trips in and out of the proposed RV site that's the subject of this rezone would exceed the threshold in Article 82607 in the commercial zone, which states that if you have a minimum or 50 vehicle trips per day generated by a commercial site, then it requires a special notice permit. So this rezone, in essence, is a prerequisite for future assessment through the special notice permit for the feasibility of developing this site as an RV park. The special notice permit will address future mitigation of vehicular traffic, perhaps pedestrian traffic, if the property owner of the waterfront property will allow those folks that are on the RV site to access the lake via their waterfront parcel. It's unknown at this time. We don't know if there will be restrictions for those individuals on the RV site to access the lake through the waterfront property where the RV is currently located. Furthermore, we don't know what the scope of the proposed uses and development will be on the existing commercial site where the RV is currently located. We do have a sense that there will be some residential uses proposed, but the extent and the intensity of that is unknown, and it's irrelevant to this case. We are strictly looking at the rezone of a 5-acre parcel. Through the public comment period, we received extensive amount of comments in opposition of this request. Specifically, there were a total of 41 comments that were submitted prior to the deadline, which is 10 days prior to tonight's hearing. We have received 1 comment in support and 40 in opposition. I must say that a majority, if not all of the comments were vehemently opposed to the proposal, with the concerns over the future development of the existing commercial site, traffic impacts associated with the proposed rezone site, and the RV development of that, or the RV park development, as well as environmental impacts and pedestrian concerns across Spirit Lake Road. Staff concluded through their review of this application is that the relocation of an existing RV park from a waterfront parcel, which is partially within a flood zone, is ideal because it would be more environmentally friendly to keep it outside of the flood zone. And moreover, through the review of a special notice permit, should the zone change be approved, the special notice permit would require the applicant to comply with the design standards in the commercial zone as well as RV standards in Article 4 of our code, and we would evaluate whether or not the proposed improvements on site can further mitigate any of the impacts to the surrounding parcels. We believe that the relocation of the existing septic system and the upgrade to it to current modern standards would be beneficial to the not just the development but the environment as a whole. We believe that the special notice permit will further assess the traffic impacts associated with the RV park. And moreover, I'd like to reiterate that we, in review of the public comments, we cannot speculate what the waterfront commercial site will be developed to. We don't know. The applicant has not disclosed that, nor are they obligated to disclose what will be happening on a parcel that's not the subject of this request. We're solely looking at this 5-acre parcel that is kitty corner from the existing RV park area, and we as a department believe that this proposal with a conditional zoning development agreement does not present any compatibility challenges because the use already exists. It's just on an adjoining parcel of land. With that, I stand for any questions that you have at this time.
Not right now. Thanks, Vlad. Okay. Up here. Now we'll hear from the applicant, Rand Whitman.
Good evening, Madam Hearing Examiner. I'll speak loud and hopefully everybody can hear me. Yeah, I usually don't have trouble with people being able to hear me. I'm usually the loud guy. Vlad, is it possible, or David, could we go back to like slide 3 there? If that was...
We're not in screen sharing mode, but we
Okay.
still have the...
If nothing else, that would be fine. And if you can, it's not a big deal. Again, Rand Whitman, my address is 2992 East Gotham Bay Road, Harrison, Idaho, 83833. I'm happy to be here representing Spirit, no, I'm sorry. I'm happy to be here tonight representing Silver Beach Properties, LLC, in this request. It is a zone change from rural to commercial. I'll try not to be redundant to much of what Vlad has said. I appreciate Vlad's effort stepping in here for Zach, who's no longer a planner here. We'll miss Zach. I think Zach did a good job on this application. The site is, just go to the third slide. Perfect. Third slide. Thanks, Vlad. The site's approximately 1 mile southeast of the closest portion of the city of Spirit Lake. It's about 800 feet to the closest shoreline of Spirit Lake. The zone change, as Vlad indicated, it's proposed to allow for relocation of the existing 48-space RV park, which has existed for decades on the parcel southwest of the site. The conditional zoning development agreement has been included with the zone change, and that ensures that the RV park relocation is the only commercial use that can occur on this site. It will not become the next Walmart. To go one step further, the county also will require a special notice permit for the proposed use at this site, which will allow them to review a complete site plan, request agency comments, and impose conditions of approval, which is quite similar to the process we've used to get to this point. although we'll have a much more detailed site plan when we do the special notice permit. Essentially, the county gets a second bite at the apple with the processes that have been established for development in the commercial zone. We've requested relocation of the entire 48 spaces from the existing park. After a limited review of the current standards, I'm not particularly optimistic that 48 spaces can fit within the allotted area with the planned drain field and reserve area that's required. But we can't really know the final number for certain until all of the design and engineering is completed, and it doesn't make sense to go to that level of detail until we know where we stand on the zoning. The bottom line is that it may be fewer than 48 spaces in the relocated RV park, but it will not be more than 48 spaces. The surrounding land uses, as you can see, the closest residence is approximately 675 feet, that's down here to the southwest. The current use, you'll note, the current RV park is approximately 25 feet from that same residence. The property on three sides, to the north, the west, and the east, is used for timber production. The property to the south is owned by the Yosemite Outing Club, and that's open space as that was part of that development. So from a surrounding land use perspective, it doesn't get much better than that. Here in Kootenai County, there are very few neighbors to affect close by. Vlad went through the agency review. I'd like to touch on a couple of those. First was the Lakes Highway District. After their initial response, we took several months to get a trip generation evaluation prepared by Whipple Consulting Engineers. You've got the file and you've got the report in the file and in your packet. The report concludes that even if the RV park were a new use and not a replacement for the existing RV park, it would not generate enough traffic to have a discernible impact on Spirit Lake Road. So even if it was an additional 48 spaces, in the second review letter, the Highway District accepted the conclusions of the report, and so the traffic that results from the relocation of the RV park is simply not an issue. Other agencies also provided comment. The Health District, also as Vlad touched on, recommended a review of the soil conditions to evaluate the feasibility of the drain field use on the site. The Health District evaluation of test holes will be done during the next phase of development approvals of this site. We're familiar enough with the site to know that it is well suited for drain fields. That said, there are numerous alternatives for handling wastewater from RV parks. On-site disposal in a drain field is only one option. We are confident that the RV use is viable regardless of the outcome of our work with the Health District. The Fire District and the City of Spirit Lake also responded to the county's request for comment. Those were mostly their standard comments. Just to address the comprehensive plan, I think staff did a good job of covering the comprehensive plan in the staff report. I don't think an additional analysis is necessary here unless you have questions about it. I would refer you to the staff's analysis. And then I would also just touch on the public comment that we've received. There have been quite a few comments so far in the record as a result of the notice. There are 5 or 6 themes to those. I'd like to touch on a few of those. The first issue is the concern for water quality. We are confident that this proposal is beneficial to water quality in the lake. The existing RV park has numerous wastewater disposal facilities. Some may comply with the current regulations, some probably not so much. This proposal eliminates this system in favor, eliminates those systems in favor of new facilities that comply with the current wastewater disposal requirements, and they are all located much farther away from the lake. There's nothing in this proposal that poses a credible threat to water quality. Traffic impact is another common theme. As I previously mentioned, we have done a trip generation study that demonstrates that no significant impact on the road there. The Highway District has concurred with the conclusions of that report. Another comment in the comments received to date is this issue of pedestrian traffic. This zone change does not attempt to address pedestrian traffic from the RV park to the waterfront. The owner is under no obligation to provide waterfront access to the RV park patrons. If this is an amenity that will be maintained, and we hope it will, we will work through that issue as part of the special notice permit. And if we can work through that with a walking trail and an appropriate crossing, we will do so. Great. If we cannot, then obviously we will do something different with that waterfront piece, and it will not become an amenity for the RV park. The last one I'll touch on is regarding future uses on other parcels. As you know, and as staff has indicated, they're simply not relevant to the zone change request. Future uses on other property owned by this applicant will be in accordance with the zoning that exists there and will be reviewed by the county when and if the uses change. If it is something that requires a public hearing or public notice, the public will have their opportunity to offer their opinion on it. The zone change, however, stands on its own based on the current conditions and can't be based on some speculative future use. In closing, I would just say that this request allows the property owner to modernize a long existing use, to bring it into compliance with current standards for water quality protection, wastewater disposal, flood zone compliance, and transportation safety. It benefits the neighborhood, allows continuation of a long existing use, and is the right thing to do. And we respectfully request your recommendation for approval. I'm happy to answer any questions you might have.
I don't have any right now. Thanks, Rand.
Thank you.
And Stephen Ford, also applicant representative, who wishes to speak.
Thank you. Good evening. Besides being the applicant,
Name and address, please, for the
Stephen
record.
Ford, 320 South Sullivan Road, Spokane Valley, Washington, 99037. In addition to being the applicant, I guess I'm the owner. Really, my main comment is simply to address any concerns that my neighbors may have that some random developer is coming in and attempting to change the lake drastically. My family has been on the lake since the 1970s when we first purchased property in the Christmas Tree Resort. Later, we've purchased property in Bronze Bay. We now own property in Lake Haven, Silver Beach, and Bronze Bay, and recently purchased another property in Bronze Bay to build another cabin. So the thought that I would somehow be involved in anything that would have a detrimental impact upon my personal use of the lake is simply unfounded. I grew up on the lake. I raised my children on the lake, and I currently have my grandchildren spending the summers on the lake. So I have a vested interest in not doing anything that adversely impacts my use of the lake. The beneficiaries of that selfish desire are all of my other neighbors and residents of Spirit Lake. In addition, including the RV park, some of whom have been decade-long residents in that park. Instead of simply dismissing their legacy, we're attempting to accommodate their desire to remain in the area. I'd be glad to answer any questions.
I do have a few. I was out looking at the property, and it would appear that you do have a lot of long-term RV residents. And I assume they're under leases.
Annual is all. In fact, they rent 5 months at a time from May through September. every year.
And they're not removing their RVs from October through,
Most of them actually do remove them. There's a few that keep them there through the winter, and we allow them, we charge a storage fee of $50 a month and allow them to keep them there. But the majority of them are removed. There are a couple of permanent type structure trailers that actually we own.
having spent a long time in the commercial real estate development business, I know that some tenants can be rather obstreperous when you want to get them to do something. What devices do you believe are in existence to make sure that if you create these new spaces, that they'll actually move and not, so you'll have two operations going because you can't get rid of them on the existing spaces?
We don't have any concern about them leaving their current space. There really are only a couple that store them even. The rest of them will remove them, and in 2 weeks it'll be virtually empty. So that hasn't been a concern. And we won't be operating, even if the zone change is approved, we wouldn't be operating two parks. The idea is to simply provide them with an opportunity to select a space and to move. How long this has taken this year, we've already let them know that we'll be operating the park next year status quo. It'll be the same as it has been for the last, 50 years. So we're stuck operating it for at least another year. We're spending several $100,000 redoing a dock because there's a public marina on the adjacent parcel to the RV park. So we're attempting to upgrade everything. The RV park, as Mr. Whitman indicated, seriously needs to be upgraded. It has some serious problems that need to be addressed and have simply been ignored or grandfathered in. We could continue to do that, but that's not how I've operated in the past. I want the lake to be better, and I am in a position to be able to do that.
Okay, thank you.
You're welcome.
All right. We have no comment sheets from those who are in favor and none who are neutral. We have those who are opposed. And I apologize in advance for mispronouncing your name or having a hard time reading your penmanship. Sid Würzburg is opposed and wishes to speak. Did I do that right?
Yes, you did.
Okay.
My name is Sid Wurzburg. I bought my property in Bronze Bay in 1976. In 1999, I went through a lot of trouble to get septic permits and built a new home and have lived there since then. I have very real concerns for a number of reasons. One is Steve's effort to limit this to the one property. These are three properties that are totally interconnected. They can't be separated. The big problem I'm having is with the fact that the existing RV park is on reclaimed marshland. There used to be beaver dams in there. There are plenty of comments from people who remember playing there with beaver dams, and Mr. Ford did not do the illegal filling. But the fact is that his predecessors. The land that he described, which is the land you're considering now as flat, if you look at the site of future proposed RV park, you can see a giant hole. It's not flat. That's the hole that all sorts of fill was taken out of by historical accounts to put into the current RV park site. It was filled. That was done prior to the time when the law prohibited that. However, that huge hole was there. You can see from that picture, this is a very sandy soil. It's a soil that was used, again, not by Mr. Ford, but by predecessors. They brought sand up to block off that natural wetlands. They piled it up. When I first got there, the pile was there, but every year at high water, as you have many comments talking about it, that filled up. They kept piling more and more of the sand to raise it. The water didn't go over the top of the sand, except in the very early years. It went through it because it's sandy and porous. And what happens, unless they've changed the rules of physics, what goes in there, when the water drops down, comes back out the same way. And anything that's there winds up in the lake. We just got terrible problems there. Now, if you look at my written comments, the one thing I think is really important, Tony Zwink from Panhandle Health said it was approved, but, and this is a quote, however, it is highly recommended for applicant to apply for a speculative site evaluation through our office. Site suitability for septic remains unknown at this location. Property may be unsuitable for septic or may not meet economic functionality for the applicant. I think what that says, it's unsuitable for septic, so you're going to have to put in some sort of a sewer system, which may mean it's economically not feasible. And when you have Panhandle Health giving cautions like that, you have to do those additional studies. And you have to look at these parcels as a whole. This is in the areas 1 and 2 of the Spirit Lake City area of city impact. The city has shown no interest doing that for obvious reasons. A lot of people in their comments talked about traffic on the road. Well, you heard that it's going to be 800 feet to the water.
That's an indication that your 5 minutes are up.
What?
That's the indication that your 5 minutes are up.
Oh, okay. You can't walk that 800 feet. People are going to be in RVs. They're going to be crossing the road. The traffic is huge.
Thank you for your input. Jana Harvey, opposed, may wish to speak.
Good evening. My name is Jana Harvey. My address is 4036 South Easy Lane, Spokane, Washington, 99223. Our property is immediately adjacent to the existing RV park and has been since 1929. We've enjoyed many years of favorable relationships with the people in the RV park, so that isn't an issue at all. My issue is Spirit Lake Road and the hazardous nature of that blind corner If you were there, Ms. Woodward, you are aware of that situation at that curve. Our access road is North Crater Court, which is referred to in the plan by Mr. Ford. We are desperately afraid of the children and the people that will, and no doubt will, make their way from the new RV park down to the water. That road is extremely dangerous. It has been near misses many, many times for all of us in that area. That really is my concern. I am representing Harvey families that reside in our cabin, which is a duplex now. But we want there to be a good impact with the issues that have been raised, for instance, the water issues. It would be our hope that Mr. Ford, if he is able to replace the RV park, that there is adequate changes made to the property right next to us. And we look forward to maintaining a good relationship with Mr. Ford in the future. But we are opposed to the rezoning. Thank you for your time.
Thank you. Kevin McHenry, opposed, wishes to speak.
Kevin McHenry, 3734 North Purcell, Coeur d'Alene, 83815. I am opposed to this for safety factors, as everybody knows. You have a family of kids, a dog, older people crossing that road. Somebody's going to get run over. Spring, winter, fall, no problem. Peak summertime, logging trucks and everything else. And I've been going up to Browns Bay for 60 years. I have noticed the water quality decline through those 60 years just because of human affluence. So if they go down there and develop that, the old RV park, how much more affluence is there going to be? There's going to be boats, sewage problems. I mean, who knows? It's this is the first domino in a string of 20 feet of dominoes. That domino, the first one, is the first chip. That falls, and then it just keeps going. And there will be problems down there. That's all I have to say.
Thank you very much.
Thank you.
Leslie Ann Tunnel, opposed, does not wish to speak.
Correct.
Carol Capre, opposed, and it doesn't say whether you wish to speak or not.
No.
Okay, thank you. Diana McHenry, opposed, does not wish to speak. Yes, okay. Kevin McHenry, opposed, does not wish to speak.
No, I already spoke.
Oh, right. Oh, so you filled out two.
She did.
Ah.
She thinks I'm old.
Okay, then that's all the public comment sheets we have. Let's go to Zoom and see if we have anybody there.
Is there anyone on Zoom that at this time would like to speak to this issue? Raise your hand on the Zoom.
And in the meantime, did you fail to fill out a public comment sheet? They're the blue ones behind you.
Oh, we didn't know that. We sent one in
Email.
We got all those, but if you wish to speak and be on the record here now, you need you to fill out and we'll get to you.
Again, if there's anyone on Zoom that would like to speak to this issue, just unmute yourself at this time and go right ahead.
I would like to speak.
Go ahead. Please give us your
I'm
name.
Jack Wade. I live at 7948 West Spirit Lake Road. Of course, the safety crossing the highway is quite an issue. I drive a log truck occasionally, and the road's just not up to those standards. But also, if you put all those RVs across the road next to that hillside, you know, teenagers are gonna be teenagers. They're gonna sneak off and smoke cigarettes up there in the trees, drink beer. That hillside is crispy dry every year. And you're gonna put that many more people on that hillside, it's gonna catch fire. There's not a doubt in my mind. I see it happening at Settlemeyer's. Kids are always sneaking off in the trees. Garbage is everywhere. I am thoroughly against a zone change here. Nothing should happen over there at all.
Okay, thank you. Anyone else on Zoom?
Going once, going twice.
Okay, and we have one more public comment sheet. You didn't indicate whether you were in favor or opposed. It's Bruce Mcbride.
Yeah, I'm opposed to more so concerned.
Okay, and you wish to speak, so please come forward. And name and address for the record.
Name's Bruce McBride, 30334 North Crater Court, Spirit Lake, Idaho. My concern is that they're saying that properties are separate, right? And that you allow it to become zoned commercial, right? Well, that means the other property is still zoned commercial, and they haven't said what the stated use of that property is going to be. So what if they decide later on that they want to put in condos? Where you're going to double the amount of people in that small area. And, you know, like everyone says, I walk that road absolutely every single day. I walk 6 miles a day. And that corner is the most dangerous corner I actually walk on. And I really do worry about getting hit by a car. So I don't know if they're going to, you know, if they're going to put something over there, are they going to build a tunnel? I can't imagine doing that. It'd be extremely cost prohibitive. But I mean, even though you're going to say, you know, parents should watch their kids cross the street, kids are just going to run across. I mean, that's just what kids do. And there are logging trucks. I dodge them all the time. But, you know, I'm an adult. I'm sure a 5-year-old isn't going to be paying attention. My dad got hit by a car at 3 years old. It happens. So my biggest concern is them not stating what the proposed use is of the property once the RVs have been vacated, and what impact that will do if it's a commercial venture such as condos. Thank you.
Thanks. So we got all the public comment that so, okay, we'll get to rebuttal from the applicant.
Thank you, Madam Hearing Examiner. Again, Rand Whitman for the record. My rebuttal comments will be brief. I would just start with the question of the interrelated nature of the three properties. They certainly have been used in an interrelated nature over the last many years. That may or may not continue. We just don't know. We need to, in order for us to move forward with our planning on the rest of the property, we need to start eliminating some variables. And one of those is what happens to the RV park. You know, can we relocate it and move it across the street and allow those people to continue to enjoy the area? Or does it just get eliminated? Or does it get does it remain in its current location? I think, based on my conversations with the owner, I think it's unlikely that it stays there. And so, long-term, the question is, do we provide a place for those people that have used it for many years across the road or not? And we simply just need to know that so that we can plan, what happens on what we do with the rest of the property. And so it doesn't make sense for us to spend tens of thousands of dollars on hypothetical scenarios, and we could come up with several different scenarios for what we do with the remainder of the property. And so we believe strongly that the zone change can stand on its own. Either it's appropriate to move that RV park over there or not. And if not, that just sends us down a different path. And we get on with our planning for the rest of the property. And so, again, it is the first step for us to complete, really to embark on our planning effort for the rest of the property. Septic suitability, again, we will complete that effort with the health district. As you heard in the testimony, the soils over there are sandy. They are low gradient. And so we're quite confident, I'm quite confident they will be considered to be a Class A soil, which allows for the smallest drain field sizing. We will be limited by the number of RV spaces and the amount of effluent that can be generated on there. The health district has criteria for it in their large soil absorption system criteria that limits how many gallons per day can be discharged into a septic system without going to this separate criteria, which nobody can really comply with. So we'll be constrained by what they call it the LSAS criteria, which is 2,500 gallons per day. I believe that will be a limiting factor for us. There are other opportunities for RV parks, such as having RV dump stations into a holding tank, hiring pumping services that can come once or twice a week and pump out RVs. These are all acceptable alternatives for RV parks under the health district's guidance. And so I'm not concerned about the ability to do an RV park there because of septic limitations. Some are more cost effective than others, but it doesn't prevent us from doing an RV park there. Again, lastly then on the traffic, I didn't say this earlier, but part of our proposal, we will have to relocate the approach onto this parcel, gets relocated to the east end of the property. So farthest away from that, we've got a corner there, we've got a horizontal curve in the road alignment at the southwest corner of this property. We've also have some we've got some hills that limit sight distance. And so in our conversations with the health district, the vehicular approach has to be moved to the east end of the property, which we acknowledge, and we'll be doing that. Again, we will be looking for different options for a dedicated pedestrian path. We are not excited about the prospect of having pedestrians walking down the street. That's a non-starter for us. And so, we think a dedicated pedestrian path is necessary. Maybe that is partially within the right-of-way, but, it may also be on the private property that is off of this zone change site, but still owned by my client. So we believe we can solve that. And, we have the opportunity to do that. and prove that up to the county before the use is approved in the special notice permit process. And so, with that, again, we would respectfully request your recommendation for approval. I'd stand for any questions if you have them.
I think it might be helpful if you talked a little bit more about the special notice permit, because a lot of people don't understand what happens with that.
Sure. So it is like a light version of a conditional use permit, is the best way to describe it. We have to go through a full application process with the county with a narrative, a site plan, an application, fees. The county sends it out to review to the agencies, just like they do a conditional use permit, similar to what they did for this zone change. The agencies review it and get those comments back. It also gets sent out to adjacent property owners, which within, you changed the requirements on me, so I never know what the radius is, but I think it's 500 feet. It'd be the same radius that notice went out to for this. And they are given 30 days to provide public comment in the same kind of time frame that the agencies are providing comment. And at the end of that, David gets the distinct honor of reviewing all of that and making a decision and imposing conditions as necessary and appropriate. He's heard the testimony about pedestrian safety. I fully expect that, that will be an important consideration for him. I expect that will be something that the Highway District will be requiring us to address in detail as well, along with other concerns that come up here. And so there is no public hearing per se for it, but there is the opportunity for public comment. And it is it's an approval that it's done administratively by David. That is the special notice permit. And
Madam Hearing Examiner, like your next item, it's appealable.
Lucky you.
Going to get some extra experience.
Yes.
Vlad, you have a comment as well?
I would like to just add on to what Rand had stated about the special notice permit process and address the section of the code that gives the direction for future need of a special notice permit based on the traffic generated by the specific.
You come up to the mic, because I think it's helpful for people to understand. Thank you, Rand.
Thank you.
Because it isn't something you see every day.
Can everybody hear me?
Yes.
Okay, so I'd like to add on to the testimony by Mr. Whitman by stating that one may ask whether or not the county would require a special notice permit in this case, should the rezone be approved. According to the project file that we received from the applicant, a trip generation analysis prepared by Whipple Engineering. The analysis of that study state that the proposed RV park, even though it's already there, but the relocation of it on its own would generate approximately 120 daily trips. According to section 82607, every time staff is tasked with assessing whether or not any commercial site that is adjacent to a public road requires a special notice permit, we have to evaluate the intensity of use. And so what we ask for is we ask for the applicant to present us with a synopsis of their request and a trip generation analysis based on the ITE manual, engineering traffic manual that assesses peak trips, AM and PM peak trips, as well as daily trips. And what the code says under section 82607, subsection 1 and 2, it says for sites which access directly onto state or federal highway, 25 vehicle trips per hour or 250 vehicles per day would not apply in this case because it's not adjacent to state highway. But the second item states for sites which access onto public roads, 50 vehicles per day requires special notice permit. Given this document in the project file, we would automatically request.
Pull it back a little bit.
Sorry, I'm getting feedback myself. So given the fact that the trip generation analysis submitted for the rezone has evaluated that the amount of trips would exceed the threshold requiring a special notice permit, it's a guarantee to the adjacent property owners that should the rezone be approved, staff would not allow any development of the site, including site disturbance permits or building permits, without further evaluation or further review of a special notice permit. Does that help?
Yes, I think that does. Thank you, Vlad. And that concludes the hearing on ZON 20-0013.
I had 2 minutes left.
I'm sorry, I have to close the public testimony by, once we've closed that period.
All right, have a nice night.
Thank you. Okay. Thank you. Okay, I didn't know that we can, oh, he's, I know, yeah, let's see.
Now he says he's opposed to the appeal. So they couldn't hear.
I know. And it's hard. Don't feel bad. It's hard to, I think,
Lost the PowerPoint.
I know. I
One 0001. It is an appeal, and we have different procedures by which we must follow. And I'll ask to clear the back of the room so that just this matter is addressed with, yes, thank you very much. Appeal hearings go a little bit differently than zoning and conditional use permits. My task is to make sure that there is full disclosure of all relevant facts and issues. The submission of evidence and testimony is limited just to the appellant, representatives of the department, and other affected persons. We're going to follow the following order. We'll introduce the appeal or request by the staff, then we'll go to the appellant's case in chief, then we'll have testimony or evidence in support of the appellant, county's case in chief, then testimony and evidence of support of the county, and then appellant's rebuttal. Are there any questions? We also, but I'd like a little input from you all as well, can limit the amount of time provided to the parties. I know earlier today we had some conversation back and forth with regard to 30 minutes needed. I kind of don't think you guys need that much time.
I've timed my case in chief to 18 minutes, Your Honor. 18 minutes.
How about 20? Can we go with 20?
Yes, that's fine.
Okay, good. Thank you for being cooperative. All right. Then we are opening the testimony for case number APP 21-0001. And staff is going to start.
Madam Hearing Examiner, I'm David Callahan, Kootenai County Community Development Director. And this is an appeal of my decision. For clarity's sake, while it's true that Mary Shaw actually signed the order of decision, she did so acting on my behalf. You are unfamiliar generally with minor subdivisions, so in my opening, I should explain a little bit of how they're different. Minor subdivisions are those that are 4 or fewer lots. Major subdivisions are 5 or more. There is frankly a loophole in our current regulations that I'll speak to when it's my turn, and it coincides with some of the concerns raised by the appellant and others. But the main takeaway is that ultimately this is an appeal of my decision. I believe the staff has properly reviewed the case before you. I think the decision was correct, and I'll explain why when it's my turn to do so.
Thank you. Okay. We're ready for the appellant's case in chief, which I think is Ed Holmes?
That's correct, Your Honor.
Yes?
So I keep on saying, Your Honor, as an occupational hazard on my part.
Oh, it's so, ego boosting. Thank you.
And if I may approach your dais and prevent you documentation here.
Thank you. And we're going to label this,
HG 1000.
okay?
Since the county is going to be responding, I'll give you a phone copy of that. And those, it's paginated at the top, so if there's any references. No, unfortunately I don't. I will, thought I was going to give it to you actually, so. No, this is all being presented today.
I think she can use mine.
Okay, that's fair enough, yeah.
At the end, I just want it back.
Well, I can send you a copy.
Sure.
Yeah. Okay. All right. I saw somebody speaking in one of these. I have to speak in that, or anybody hear me? Okay.
I think your voice carries pretty well.
I've been told that. Okay. First of all, my name is Ed Holmes.
Don't actually need 2 of these.
Okay. My name is Ed Holmes. My address is 1250 West Ironwood Drive, number 301 in Coeur d'Alene, Idaho. I'm an attorney who's licensed in the state of Idaho, and I'm here to represent the Pierce Family Trust and the Pierce Investment Group 1 LLC. And my clients are the owners of a real property that is adjacent to the appellant's property holdings. And before I begin, I do want to extend my thanks to everyone who has supported the appellant's position in this matter. Some very, very well thought out and very well written statements of support have been submitted. In fact, probably better than my own presentation there. So I do appreciate everyone who has voiced an interest in this appeal and especially in opposing the current application. Now, the primary basis of the appeal is the partition agreement issue, and the failed attempts of the applicant to unilaterally amend the partition agreement. The other points of the appeal are misuse of the minor subdivision process, incompatibility with the neighborhood locale, incompatibility with the comprehensive plan, and a lack of cooperation on the part of the applicants. And I'll start with the misuse of the minor subdivision process first, because it puts the applicant's property holdings into historical perspective with a whole series of deeds that have been recorded by the applicants and their various corporate entities. Now, this application is originally brought under a minor subdivision application, as stated in the very beginning of this process, and pursuant to County Code 8.6.301, the minor subdivision process may be used to create 4 or fewer lots if the property has been subdivided within the past 5 years, or if the previously divided subdivisions together will recreate 4 or fewer lots. The term property, for whatever reason, is not defined by the county code. The term parcel is defined by the county code as any portion of land that is separately described in the deed of conveyance. The county code also defines a lot as a platted parcel of land which has been legally created. So there's a distinction, a very a keen distinction between the terms parcel and lot, and unfortunately undefined term of property, which I would probably, the definition of property probably is more in tune with the definition of parcel under the county code. Now, under the county code, specifically 8.4.11, there are various historical dates that are critical in establishing whether or not a parcel is eligible for any county permits. One of the dates is being a parcel of record on or before January 3rd, 1973. Another is whether or not the parcel was of record on or before November 17th, 1995. And most importantly for this matter is County Code Section 8.4.1101.c and subparagraphs 2 and 4 of that particular code section. Subparagraph 2 states that a parcel created by a deed describing property by metes and bounds or aliquot parts, which was executed after November 17, 1995, and subsequently recorded in the office of the Kootenai County Recorder, shall be deemed to have been created as of the date of recordation. And subparagraph 4 deals with remainder parcels, and the term remainder parcels may become important here in just a moment. A remainder parcel states that a parcel created by a deed describing the property by metes and bounds or aliquot parts, which was executed after November 17, 1995, and subsequently recorded in the office of the Kootenai County Recorder, shall be deemed to have been created on that date of recordation. So those two subparagraphs are applicable in this matter. And now we'll get to the little notebook here. The applicant, Everwell LLC, is owned by Roy and Nancy Newton. The Newtons also own two other Idaho limited liability companies, one known as CAV OK LLC, and the other one is Rock Island LLC. On October 24th, 2006, Nancy Hawkins, on behalf of CAV OK, recorded a quitclaim deed in the county records as instrument number 2053021,000 that purported to establish two parcels of property. And if you turn to page 6 and page 11 of the documentations that I gave you, page 6 is the first page of the deed that was recorded on October 24th, 2006. And on page 11 is a map that was attached to that deed as well. And that map shows two parcels. One is called Parcel R, and for this appeal, there's also Parcel A. And Parcel A is described as a 856,541 square foot parcel of property, and that equates to about 19.663 acres. Now that remainder Parcel A, in fact, is even defined as a remainder Parcel A in the first page of this deed, which again is at page 6. And it is a combination of three tax numbers to create this self-described remainder parcel as of 2006. And as I said, based upon the definition of lots that I just stated, that date of recordation creates this parent parcel. And I seem to have just knocked off some, there we go. Sorry. Okay. The remainder Parcel A, which again shows up on page 11 here, was created and established as of October 24, 2006, pursuant to County Code, and the remainder Parcel A shown on page 11 is the parent parcel of both the original Axis Cove subdivision and the current Axis Cove First Edition application. If you turn now to page 14, that is a map from the title policy that was submitted in the application, and it shows the outline of the real property, which is the subject of this particular application. That's Axis Cove First Edition, the proposed Axis Cove First Edition. Then, if you turn to page 17. Page 17 is that same map that is part of the original application, but it has the overlay of that 2006 remainder parcel, Parcel A, that was created in 2006. So it's obvious that the Axis Cove First Edition subdivision is located within this original parent parcel created in 2006 by CAV OK. And because the remainder parcel includes the Access Cove First Edition subdivision application, but also contained the first original subdivision of Access Cove. And that's where we have the problem, because the common parent parcel of both the Access Cove First Edition and also the original Access Cove are from the same parent parcel. And I'll get into the timing about that later on in this presentation, but that is a very crucial point, is that both these subdivisions are within the same parent parcel. Now, getting back to the earlier subdivisions of the remainder parcel A, going through my time here, on August 31st, 2007, CAV OK conveyed a portion of the remainder parcel to Mr. and Mrs. Scott, and that is designated as parcel O on pages 22 of the attached, and the deed is actually at page 23. And if you look at page 22, you can see parcel O as it's located within the 2006 remainder parcel A. Then, on December 17, 2007, CAV OK conveyed a portion of remainder parcel A to the Wasserkrug Trust, and that parcel is known as parcel C. If you look at pages 29 and 30, you will see where parcel C has been conveyed out of the 2006 remainder parcel. Then on December 2nd, 2009, CAV OK conveyed all the remaining portion of the remainder parcel A to its associate, Rock Island LLC. This conveyance established parcel K and the remaining portion of the remainder parcel of A. And the different maps needed to point this one out. And if you look at pages 38 and 40 of this document, you will see the new created parcel K, which is actually on, you can see it, page 39. And then on page 38, you see the remaining portion of the original parcel A from the 2006 conveyance. Then, on October 1st, 2015, Rock Island recorded a deed establishing 10 new lots within the remainder parcel A. And that is shown at pages 73, 84, and 93 of the attached. And these parcels are identified in the deed as 5 upland parcels, T1A through T5A, then 5 very small flag lots, also designated T1A through T5A. In addition to creating all these additional lots within the parent parcel of created in 2006, they also deeded the rest of the remainder parcel A and consolidated it into a larger 107-acre parcel of property. On August 1st, 2018, Rock Island once again recorded a deed reconfiguring the various internal lots, the remainder parcel A, and conveyed everything to the appellant, the applicant, Everwell. Again, all these entities are interrelated. On April 1st, 2019, Everwell applied for the minor subdivision of a portion of the original remainder parcel A under county application MIN 190023. This application sought and obtained a 2-lot subdivision of a portion of the original remainder parcel A, and that area that was subdivided was known as parcel K originally. And if you look at page 122 of the packet, that is the order of decision establishing the original Access Cove. It shows the parcel K configuration that was set forth in the earlier deeds of conveyance. And again, this is all part of the original 2006 parent parcel. Now, the subdivision application of the MIN 19-0023 represents the first county subdivision of the 2006 remainder parcel A, and that application was approved on September 9th, 2019, creating 2 lots. Based upon the original parent parcel created in 2006, the next permissible application date for a minor subdivision relating to the 2006 remainder parcel is September 2nd, 2024, pursuant to County Code 8.6.301. Now, at page 6 of the staff report states that the County Land Use and Development Code does not currently prohibit submittal of applications for minor subdivisions on parcels of land adjacent to recently approved minor subdivisions. That is correct up to a point. The critical distinction is that the real property that is the subject of the current application is not only adjacent to this other subdivision, it was part of the original parent parcel that was created back in 2006. And that is the issue, is that the new application is part of the same parent parcel as the original application, and the timing has not expired. The timing is 5 years between each of those minor subdivisions, and that has not occurred for this particular subdivision. The application is premature and should be denied without prejudice, and the applicant should be required to wait the full 5 years after the first minor subdivision to apply for another minor subdivision of the 2006 remainder parcel. And again, that will be in 2024. Turning to the issue of compatibility with the neighborhood and the county's comprehensive plan, particularly in lot size, again at page 6 of the staff report, there is a statement that there are examples of parcels having 1 acre or less farther to the south along Newton's Way, most of which are unplatted, unquote. Then on page 7 of the staff report, there's an additional comment. There are existing parcels of comparable size in the area. As before, that is correct up to a point. The southern parcels along Newton Way are unplatted parcels created by the applicant through an extraordinary series of documents re-recorded and re-recorded and then re-recorded numerous times by the applicant's representatives over a series of years. In 30 years of looking at title work, I have never seen such a cavalcade of recordings and re-recordings before. And it's mind-boggling what they've done. And for what purposes is the question. What I've provided today in this handout is just the tip of the iceberg of what the documentation has been recorded by the applicants relating to their property holdings in the Sweet Bay area. The only purpose I can glean from this amazing amount of recording is an attempted shell game of moving property boundaries and ownership around to such an extent that it is difficult to track the legal lots from the illegal parcels. Basically, the forest from the trees, as it were. The questionable lots to the south, all created by the applicant, should not be used as a basis for comparing neighborhood compatibility or compliance with the comp plan for this particular application. What you should look at is the other lots that are unassociated with the applicant, and I think the stated statements in support of the application beautifully set forth the arguments on that point. Now I want to get to point 4, the lack of a meeting or cooperation by the applicants. At page 7 of the staff report, it states that the applicants are encouraged, but not required, to meet with the neighbors, unquote. And this is to ensure that proposals do not result in civil disagreement with neighbors. Well, since the neighborhood meeting is not a requirement, there's not much for me to argue about legally about a lack of a meeting. But I can certainly say that the applicants have not been cooperative or forthcoming whatsoever in this matter. And the refusal to be cooperative has resulted in a civil action being lodged against them by my clients. And that brings me to the final matter, the slanderous attempts by the applicants to unilaterally amend binding private land use contractual agreements. The subject partition action, or excuse me, the subject partition agreement, along with the secondary document, the modification agreement, along with the documents that the applicants ginned up to, are now in litigation. And the copy of the complaint is included in the package of this packet, and I believe it's at 132. Yes, it's 132. I filed this on Monday. I'm still waiting for it to be processed through the court system, but it is the appellant versus the applicants, along with everyone else within that's been named in the partition agreement. So a lawsuit has been filed. And this particular venue we're at today is not the appropriate place for adjudicating the validity of the various land use documents, but I do want to point out a few matters for the record. Page 5 of the staff report, it is acknowledged that Nancy Newton knew that my client was a necessary party to the land use modification documents that Miss Newton drafted, and I call those the Newton documents in the complaint. She included my client's name as, quote, party hereto to the Newton documents. She also referred to my client's property holdings on the Newton documents with the name of Pierce noted on the map. The staff report also acknowledged that the fact that my client received a copy of the Newton document and that my client refused to sign those documents. The staff report also acknowledged that the fact that the Newton documents were recorded even though my client was specifically identified as being a property owner in the Newton documents, stated as being a party hereto to the Newton documents, and did not sign the Newton documents. Going further down page 5 of the staff report, there's a statement that the applicant, quote, provided a thorough analysis of why the subject private restrictions are no longer applicable, unquote, based upon, what? Oh, I'm sorry, I thought you were cutting me off. Sorry about that. My time was up. I lost my train of thought. Okay, provided a thorough analysis of why the subject private restrictions are no longer applicable based upon the Newton documents. The reference legal analysis of the applicant is dated April 30th, 2021, and is part of the attached. I think it's the last document attached. And first of all, it was very difficult for my client to even obtain a copy of the applicant's legal opinion. For whatever reason, the legal opinion was not referenced in the approval order, and my client only became aware of the legal opinion weeks after the original decision. When my client asked for a copy from the county, he was told to get it from the applicant. When he asked the applicant once again showed the extreme lack of cooperation, and after more than 10 requests to the applicant for a copy of this legal opinion, my client finally had to go back to the county and ask for a copy from the county. We eventually did get a copy from the county. After our review of the opinion, I think that the opinion wildly misstates Idaho law regarding amending private land use covenants, and I see why the applicants didn't want it released. More to the point, it blatantly ignores the fact that my client did not agree to the Newton documents, and it makes the incredible, self-serving, unsubstantiated, incorrect statement that Nancy Newton, on behalf of the real property owner described herein, recorded an amendment removing any and all restrictive covenants which had previously prohibited development for multifamily dwellings or more than 4 single-family dwellings. This is an absolutely wrong statement of the law based upon the very facts of the record before you. Nancy Newton knew my client was a necessary signatory to the Newton documents, and she included my clients on the documents. That was my time, right?
That was 20 minutes.
Okay. Well, with that, Your Honor, hearing officer, I will cut my comments very quickly, is that based upon the parent parcel issue and based upon the pending litigation, the appeal should either be tabled pending the resolution of the lawsuit or the application should be denied based upon the parent parcel issue.
Thank you.
Thank you.
Okay.
I should be up next, I think.
Yes. Yes. Now we'll hear from the county.
Madam Hearing Examiner, I'm David Callahan, Kootenai County Community Development Director. By way of background explanation, you have some 200 pages of staff reports, staff introductions, and applicants and appellants' view of things. I'm not planning to go through much of any of that, with some few exceptions, which will take 4 or 5 minutes. But it's worth noting that the planner that handled this case is on vacation and will be leaving us, and so that's why he's not here tonight. But I do have Mary Shaw on Zoom in case there are details to the case with which I'm unacquainted, and she can backfill for you. To me, from what I see of this, the central issue is the 67 partition agreement and then the subsequent changes to that agreement. You've heard one view that it's not valid. Our legal counsel thinks it's entirely valid. And since the staff doesn't pretend to play law, we go by our legal counsel's opinion. Also, along those lines, the thing that I believe Mr. Holmes glossed over is that I'll show you an image in a moment on the screen, there are various boundary line adjustments that are entirely allowed by law. And that creates a different starting point than, I believe, the original partition agreement or subsequent agreements contemplated. But nonetheless, our legal counsel, in looking at those boundary line adjustments and where we are today, believes that what you see in the very bottom of the slide to your left prevails, which is Tract A and Tract 1, which include the item before you, may be divided in any lawful manner. I will leave to the attorneys and courts as to whether that actual amendment is valid, but again, my legal counsel thinks it is. Concerning the issue of multiple minor subdivisions subverting the major subdivision process, in concept, I don't disagree. As a matter of law, I have to disagree. It is an amendment we have prepared and ready to go to the Plan Commission next month and the County Commissioners the following month to eliminate this sort of succession of minor subdivisions, which is really a major subdivision masquerading as a minor subdivision. I frankly, as a planner, find that difficult to swallow, but that door was opened with the previous the previous Board of County Commissioners in 2016, when we adopted the current regulations, and which have no prohibition against back-to-back minor subdivisions right adjacent to each other. Again, I hope to fix that. I believe I have support at all levels, but at the moment, it's perfectly legal. Concerning the issue about inadequately addressing compatibility of existing homes, you have in your hands the staff analysis of that. I'm not going to elaborate on it except to say that I believe the staff made a competent, rational, and based on good planning practice decision. Concerning the issue of it not meeting up with the comprehensive plan, again, in the staff report, you have an explanation of why we think it does. I'm not going to belabor that. And then finally, the business about encouraging the developer to meet with the neighborhood. I wish everyone would always do the right thing. I can't make them. The Planning Commission has actually drafted, and our legal counsel is working on, a possible amendment to the code which would require some degree of neighborhood meeting before things go forward. But at the moment, there is no such requirement. So in my view, we're really down to the central issue of the 67 partition agreement and whether it has been properly amended. I have a whole series of slides that the staff prepared, but I really don't know that they're necessary in case they're here in case anyone wants to refer to them. It shows you where the property is located, what it looks like today. You can see this sort of unusual boundary line adjustment which creates access to the lake, and that's been done multiple times. I'm looking for a slide that shows the major subdivision masquerading as minor subdivisions. There's 3 of them right in front of you and nearly adjacent to the one that is before you tonight. Again, our code amendment should eliminate this sort of thing in the future, but there's no prohibition at the moment. I find it irritating, but I can't actually do anything about it. That's why we have a code amendment in play. unless you have questions, I really don't know that I have anything else to add except to say that the staff did the usual thorough job of reviewing this. That original review is in your 200-page packet, and it reviews the 13 criteria that we have to look at in order to make a decision. We do literally hundreds of these every year now. The barn door was opened in 2016. And by way of explanation of what that means in reality, last year we did enough minor subdivisions to fill up 3 sections of land with new homes. You remember a section of land, 640 acres. All right. So with that, I hope I've given you enough of an overview of the staff view of these things. Are there any questions I can answer?
Not right now, thank you.
Thank you kindly.
All right. Now the applicant, right? So, is it Michelle?
Yes, Michelle Fulgham, if
Yeah.
you want to move to the opposed to the appeal.
Yes, please.
I didn't know if you wanted the appellant, Mr. Pierce, to speak first.
Would he like to? We can do that. Okay.
I have a packet that I'll be referring to. Would you like this, Betsy, or Madam Hearing Examiner?
I'll take it for now.
I'll get it eventually.
Yeah. And we're making this HE.
HE 1002.
AG 1000.
HE.
HE 1002. HE 1001 was the staff's presentation.
Thank you. Madam Hearing Examiner, my name is Michelle Fulgham. I'm a land use attorney. Been here in Coeur d'Alene for close to 30 years. I'm happy to represent the subdivision developers. Everwell LLC, Roy and Nancy Newton are here. They're longtime residents, almost 40 years here in Kootenai County. They've done a number of very high quality development projects in this area. They are invested in this community, they do right by this community, and their subdivision was properly vetted and approved by the county. This appeal should be denied, and the approved subdivision should be upheld. The county is presumed, as a matter of law in Idaho, to correctly know and apply their own ordinances. And that's what the county did in this case. They correctly applied their own ordinances, and there is no prohibition against these back-to-back minor subdivisions. This subdivision qualified on the merits, it met the criteria, and it was properly approved. A couple of points before I get into the legal analysis of the partition agreement. And one of the comments raised as part of the appeal, which as a matter of law, when a party files the appeal, they have to tell you the basis for that appeal. You will note, Madam Hearing Examiner, nowhere in any document ever presented or any comment ever presented before tonight does parent parcel. This is a whole new kettle of fish. And we don't do trial by ambush. You have to give a party notice. You have to state in your appeal, here are the grounds that I'm appealing. And then the other side gets an opportunity to respond. That didn't occur based on what we just saw. That's surprise ambush. Nowhere did they list in their notice of appeal that they claimed that the county shouldn't have approved this minor subdivision based upon this parent parcel idea. Another flawed assertion that we heard for the first time tonight was an objection and a claim that the minor subdivision approval should be overturned due to a lack of cooperation. There's no legal basis for reversing a valid, properly approved subdivision order of decision on a lack of cooperation. And again, it wasn't raised in the notice of appeal. I want to point out that when this Access Cove First Edition subdivision was approved, every single thing that Levi Basinger, the planner, assigned to this, and each and every one of the public agencies, every request, every condition, every requirement was willfully complied with by Mr. and Mrs. Newton. In fact, as evidence of their good and valid cooperation, the fire district, they came to the Access Cove development, which has a very nice road system, very nice access. And the fire district, they're fine with it, they fully approved it, but they wanted to be able to go through the Access Cove First Edition to get to Mitch Pierce's property. He's not in this development. He doesn't deserve fire protection through this project. But the fire chief asked, can I use this gate to go through to Mitch Pierce's property? He's got this massive compound, multiple building structures. It's been under construction for 4 years. It is huge. And Mr. Newton said, sure. Put your fire district lock on my gate for my Access Cove subdivision. You can use my roads to get to Mitch Pierce's property, which is outside this project. That's the kind of cooperation these longtime citizens provide to their neighbors. And what do they get? They found out tonight for the first time they got sued on Monday. Nobody told us. That's what you get. Because the county recognizes in the future there may be changes made to prohibit exactly what has occurred here, a minor subdivision and another subdivision, that doesn't give grounds to reverse this approval. Had this application come in the future after those changes have been made, sure, new rules, they apply. We were approved under the rules in place now, and there is no prohibition against this back-to-back development of minor subdivisions. I've stated in my materials, which I fully presented by the deadline, September 7th. The appellant did not. Everything was a brand new 200-page surprise tonight. I encourage the hearing examiner to disregard comments that should have been submitted in this record by September 7th. But the law that I reference regarding the partition agreement is particularly important, I think. County legal counsel is correct, as we've indicated, and as Mr. Callahan has stated, Director Callahan has stated, the amendment to the partition agreement is valid. The 1967 version that prohibited anything more than 4 dwellings was amended. That prohibition has been removed. And that prohibition was removed by the amendment to partition agreement dated August 29th, 2007. Based on that recording, track 1, which is this project, may be divided in any lawful manner which is consistent with the current zoning ordinances. Mitch Pierce, in his appeal, claims he had no notice of these amendments. That is false. That is false. In the materials attached to my letter, we have email communications, and I've also attached them on the packet, which is HE 1002. The third attachment, instrument number 206675500. Right behind that, in the packet, emails sent by Roy Newton to Mitch Pierce. Correct email address, piercem@crowntoyota.net, and Julian Pierce, piercem@coxnet. I want to go to the email dated September 27th, 2018 at 10:25:55 a.m. It's the third email in that packet. And Roy Newton tells Mitch Pierce, Mitch, good morning, great weather here. Attached is a document that was created a number of years ago when we wanted to change the long ago restrictions on your property and on ours. Your parcels are tract A, ours is tract 1. And then he goes through in this email and describes how this amendment will benefit you, Mitch, because you have 2 waterfront lots. You want to do your boundary line adjustment, you want to do your docks, you want to do your boathouse, you want to do your expansion. If you agree to this, you'll be able to do those things. And he says Jake Plummer is signing it, the Leiths have signed it, Cav OK has signed it, Rock Island has signed it. He tells everybody about those amendments. The basis of this appeal that Mitch Pierce filed was that he was never presented with such an amendment. That's his language. He was never presented with this amendment. It's unauthorized and it's fraudulent. There's the email. He got it on September 27th, 2018, 10:25 a.m. The other legal claims regarding waiver, laches, and estoppel are legal doctrines, which now that I've learned we've been sued, will be clearly and summarily seeking dismissal of these claims, because Idaho law is well established that when restrictive covenants are in derogation of or infringe upon a real property owner's ability to use their land freely for lawful purposes, courts interpret those in the least restrictive way possible. If you have ambiguity, if you have confusion, courts say you get free use and development of your land. If a party has waived enforcement of restrictive covenants or restrictions, then they are precluded from seeking enforcement of those. Access Cove subdivision previously, the previous minor subdivision, was 100 feet from Mitch Pierce's property. It's part of the same parcel that the partition agreement used to apply to. That previous development created 5 dwelling units. There was 1 existing, and then there were 4 created in the minor subdivision. No objection. No objection from Mitch Pierce. It's 100 feet from his boundary. He waived any opportunity to come in and say this partition agreement precludes development. Estoppel is the doctrine I think that really applies based on the activities of this appellant. The doctrine of estoppel prevents a party from asserting a right to the detriment of another party, which is inconsistent with the position previously taken by the appellant. C&G Incorporated versus Canyon Highway District. Number one, the offending party has taken a different position than his original position. The offending party has gained an advantage that caused a disadvantage to the other party, and it'd be unconscionable to prevent the offending party to maintain an inconsistent position. What we have are 13 recorded instruments in HE 1002. The first instrument is when Mitch Pierce purchased his property from Dr. Slaughter. That's May 2006. 6 months later, November of 2006, Pierce does a boundary line adjustment to split the parcels along the waterfront. This violates the 1967 agreement because that agreement regarding Parcel A required 200 feet for each dimension of each parcel. Mitch Pierce had 350 feet of waterfront. He split it half and half. The only way he's going to comply with the 200-foot requirement is if he has 400 feet of waterfront, 200 for each parcel. He didn't have that. So he violated it 6 months after he bought his property. Then again, in November, he established another waterfront parcel, moved the boundary at 185 feet. Again, not meeting the 200-foot requirement in the 1967 partition agreement, which he claims governs and is valid. But he's already violated it twice in 6 months. February 17, he does another boundary line adjustment. Again, does not comply with the 200-foot requirement. And this happens 13 times. He does boundary line adjustments, combines parcels, and doesn't comply with the 200-foot requirement of the partition agreement. That conduct, that rejection of the 1967 partition agreement prevents him from saying it is enforceable against us. It prevents him from gaining the advantage of 13 recorded lot line adjustments and changes, all in violation of the 200-foot requirement, but then saying, oh, that agreement still applies and prohibits you from doing 4 lots on 4 acres. That's exactly what estoppel precludes. That's exactly the legal doctrine that applies when someone violates the agreement, when they take a position that it does not apply to these properties, they're prohibited, or it's unconscionable for them to use it against us. He claims fraud. He claims that Nancy Newton committed fraud when she recorded the 2007 amendment, which said tract 1 could be divided in any lawful manner. That's flamboyant, inflammatory language. It's a ridiculous claim. And even if it weren't ridiculous, it's time barred. Under Idaho law, you have to bring fraud claims within 3 years. A claim that the 2007 recording was fraudulent would have had to have been brought by 2010, and it wasn't. I think what the appellant is trying to do is sort of bully the county into backing away from its approval by filing this lawsuit, surprising everybody with that. And the county did its job. The county properly vetted and approved a very minor subdivision. It's 4 lots on 4 acres in the restricted residential zone. It's got good road access. The agencies are all in favor of it. It meets the shoreline ordinance in a very unique and appropriate land use demeanor, which I think, frankly, they should be complimented for, because rather than putting the construction and the erosion and the fertilizer and the site disturbance, all of that down at the shoreline, they put it up on the hill. Everybody wants water access, so there's still a small portion, and then there's the community lot for water access. But the shoreline is being preserved and protected in a very unique and appropriate way, with the big development and the housework away from the shoreline. I think that's a great idea, and I think they should be applauded for doing that kind of progressive thinking. So because they fully complied, because the county properly applied its regulations, and because the developer is stopped from claiming the partition agreement applies, we recommend and request that your recommendation to the Board of County Commissioners be to affirm the approval of the minor subdivision and that it remain in place. Do you have any questions, Madam Hearing Examiner?
I don't, thank you.
Thank you.
Okay.
I believe you're down to the rebuttal.
I think I am, yeah.
Any public comments?
Not in this process. It expressly states that it's informal, strict rules of evidence do not apply, and it limits participation.
Yep. So it's time for the applicant's rebuttal. Appellant, sorry, I have a hard time pronouncing things.
Oh, hang on. The appellant was going to have a moment for his own comment? I'm fine. Okay, no, thanks.
Okay.
And since the evening is getting late, I will make this brief on just a few comments here. There is obviously there is an issue regarding the current loopholes, as the planning department acknowledges in the minor subdivision, and trying to avoid these back-to-back subdivisions. But there is a stopgap measure already in the county code, and that stopgap is the very first sentence of that county code that I referenced in my opening comments. And that is that 8.6.301, the minor subdivision process may be used to create 4 or fewer lots if the property has not been subdivided within the past 5 years. That's our stopgap measure for right now. And what I have argued on appeal, and I've given notice on from the earlier notice of appeal, that we have a concern and an issue regarding the methodology that the applicant is doing regarding the use of the minor subdivision process, and they did not take into account that the Axis Cove First Edition subdivision is within the same original 2006 parent parcel as the original minor subdivision. And because of that, that 5-year stopgap measure is what we are asking to be imposed in this type of application. And the good feeling comments about this road giving access by the fire department down to the Pierce property across the Everall property, that's a red herring because you already have an easement across that property through the partition agreement. So that's much ado about nothing. And finally, we are not here to bully the county. We are not suing the county. I'm quite fond of the county, quite frankly. We are here suing the applicants for coming up with these bogus documents that are recorded with the county recorder's office, claiming that our property is no longer subject to these private land use contracts. It's basically like if you and I enter into agreement on a contract, then I say I want out of it, and I'm going to say, do do you want out of it? And you say, no. And I say, well, I gave you notice I want out of it, so I'm out of it. That's what the applicant is doing in this matter. They waived a document in front of my client. My client said, I'm not going to sign that. And now they're saying, well, you didn't sign it, but you knew about it, so now you're bound by it. That's not the way the law works. And again, this is not the venue for that type of discussion. The venue for the discussion of the latches and the estoppel arguments and the partition agreement, that's across the courtroom in the courthouse. And that is what we're at now. And if the appeal goes through, or the appeal is denied and the application goes through, those lots are going to be subject to whatever this court case decides. And that could cause a considerable amount of problems for anybody who buys those lots during the course of this proceedings. Of course, there's going to be a lis pendens file against those lots as soon as they get a case number. So that will hopefully bar other people from buying these lots, because they may just be buying a recreational lot as opposed to an actual building lot. So until the resolution of the court case, this matter either should be tabled or the appeal should be granted and the application denied. Thank you. Unless you have any questions.
No, thanks. Would someone like to just speak to either David or Michelle, the stopgap position that he just spoke of with regard to the 5-year back-to-back?
I believe the 5-year business ignores the boundary line adjustments which are allowed by law, and that's how these lots were created, as I understand it, this one and others. And that takes it out of the realm of what Mr. Holmes just described, because a boundary line adjustment is a legal process allowed by our Land Use and Development Code outside of this minor subdivision process. And so the starting point were these new boundary line adjusted lots to go forward with the cases now before you. So to me, that's one of those rubber arrows with no point, if you'll pardon the pun.
I would agree, because by definition, it's not a subdivision. It's not subdividing a lot, you're just moving the boundary. And by definition of a boundary line adjustment, you can't create any new lot. You can't create any buildable new lot. You have to stay with, you started with 2 lots, you end with 2 lots. That's different than a subdivision. So I think the director is correct as a matter of law. They're not subdivided lots, they're boundary line adjustments that didn't change that. The court action has no bearing on what this appeal does with the county. And the county is essentially the respondent in this appeal. They're saying the county did something wrong, and the county didn't do anything wrong. And so the county should not be overturned on this land use decision, regardless of the threats they're making against us. I mean, this proceeding here in this realm is them contesting the county's actions in approving that. This appeal should be denied, the county's actions should be affirmed. Whatever we're gonna have to go fight about in court is completely separate and outside of this. And I respectfully request that be the decision of the hearing examiner.
All right. I think I have what I need. Thank you, everyone, very much. This concludes the hearing.
I would like to speak.
Oh, well,
That said, your discretion is not necessarily a requirement.
He's an affected property owner as the developer, and I think he turned in a slip.
okay. I'm in uncharted territory here with an
I
appeal.
would just refer you to paragraph
Yeah.
C under 8.8.506, where it's your call. You don't have to allow this. You may if you want.
Well, I'll go ahead and allow it, but it also means that we'll have to allow the appellant to speak as well. You okay with that?
I'll waive it, that's forbidden.
Okay. All right.
Thank you.
Then, again, we're concluding the hearing on APP 21-0001. Thank you very much.
Madam Hearing Examiner, would you mind if we took a 5-minute break?
I would appreciate a 5-minute break.
Thank you.
with case number ZON 20-0004.
Good evening once again. For the record, Vlad Finkel with Kootenai County Community Development. This is a request by Dolan Land Management LLC for a rezone of a 9-acre parcel consisting of 2 recently created lots through a minor subdivision from restricted residential to commercial. The subject parcel or the subject property is located at the intersection of Highway 41 and Highway 54, just south of City of Spirit Lake. It's located immediately to the west of the intersection of the 2 state highways. The 2 lots that are the subject of this request were formerly part of a 20-acre parcel that straddled a Highway 41. Through a recent minor subdivision of Dolan's Deal First Edition, 2 lots were created on this parcel of land that are the subject of this request. The current zoning, as I stated, is restricted residential. The property is is adjacent to parcels that are restricted residential to the north, east, and southeast. The parcel directly to the east of the subject property across Highway 41 is zoned commercial, and the remaining property that is does not have any zoning designation is within the city limits of Spirit Lake. The current comp plan designation is border. As I have stated in the previous zone change earlier tonight, the border designation, the border comp plan designation allows for limited development that will not interfere with the imminent annexation that may come in the near future. In this case, we don't know if annexation is something that has been proposed by the applicant or has been discussed with the city. As far as I know, it's kitty corner from the city limits, but it's not physically contiguous with the city limits because it's separated by Highway 41. This is the aerial overlay of the property. It is vegetated and it is sloping towards the lake heading west. It is located within the City of Spirit Lake area of city impact. As you can see, the property within the city limits, there's Timberlake High School and there is residential and commercial development heading further north within the city limits. These are some of the photos of the property. As I said, it's vegetated, and I believe in the staff report by the planner that drafted the analysis, there are some areas that are, meadows without any vegetation. It could easily be developed into a commercial development due to its size. Through the agency comment period, we solicited comments from ITD, Health Department, City of Spirit Lake, Kootenai County Building Division, and City Spirit Lake Fire District. I'd like to add that this site was reviewed and the feasibility analysis for purposes of development were vetted through the minor subdivision process. Of course, the minor subdivision process, being that it was under the restricted residential zone, contemplated residential uses. In this case, should the rezone be approved, because the subject property does abut a state highway, pursuant to section 82607 of our code, it states that any commercial parcel of land that abuts or that fronts a state or federal highway requires a special notice permit automatically, regardless of the trips that are being generated. So what that means is that this rezone would allow for a variety of uses outright permitted in the commercial zone. However, because the property is located over the Rethram Prairie Aquifer, it is self-limiting, meaning that the health department will only allow a cumulative number or a cumulative list of commercial uses that do not exceed the maximum threshold of 250 gallons per day of effluent discharge. Being that this property is slightly less than 10 acres, they will be in vicinity of between 400 and 500 gallons of wastewater discharge. So the self-limiting factor and the need for a special notice permit will further evaluate the development of this site, mitigation or impacts and mitigation. Because it was submitted without a conditional zoning development agreement, we cannot put any sideboards, but the self-limiting factor will work as informally as a conditional zoning development agreement. So in essence, this rezone is a prerequisite for further analysis of commercial development on this property. One may ask, why would this be a good candidate for rezone, being that it's adjacent to restricted residential zone immediately surrounding it? Well, as Zach Trevino had stated in the staff report, and I do agree with him, that because this is a unique location, being adjacent to a major intersection of two state highways, in our view, it doesn't lend itself to a good residential development. It just doesn't seem like a good site for residential development. It seems like it would be a good location for a commercial node, whether it's a gas station or some sort of a convenience store, just because of its exposure to two major state highways. And it's going to have great access. The ITD officials have approved an approach permit for the two lots that were created through a minor subdivision process. However, as I stated previously, it was for residential use. If the zone change is approved and they go through the special notice permit process, then ITD will have the second bite at the apple to reevaluate the recently approved approach and convert it to a commercial approach for the benefit of any new commercial uses that are proposed at that time. Through the public comment period, we received comments that were 2 in support and 7 opposed, and those who were concerned, or those who were opposed, were concerned over the future commercial development, the detriment that it may cause to the environment and surrounding development. Well, Stel believes, as I stated, that this is an ideal site just because of its unique location. The special notice permit will address and mitigate any impacts that are brought forth by the agencies and perhaps the public, and that through the special notice permit process and the requirements in the commercial zone, landscaping, screening, and buffering requirements will be addressed through site plan review and landscaping plan. This is a half-mile radius of the property in question. As you can see, there is commercial development on the other side of the lake, and the property that is across Highway 41 in the county is currently undeveloped. This is a close-up. Now, this is an interesting map of the city zoning. As you can see, the zoning is more intense than residential development because I think it's cut off, but this is designated as commercial, and this is what is it, institutional?
Vlad, let me try something. The screen's cut off here. Let me just let's see if I can get the screen back. I'm just going to switch for just a moment and then see if this brings it back.
I am almost done. I don't necessarily need to.
I know, but it's just irritating that you don't have the whole.
But that was I'm glad you put that visual in your report to see what the city zoning is right there.
Yeah, this was, I'm not going to take credit. It was done by Mr. Trevino.
Oh.
But in essence, the more intense uses and more intense zoning classification in the city limits in close proximity to this project, in our view, does not create a compatibility issue. In fact, we believe that this is just a transitioning point from city limits to the county, where the proposed commercial zoning classification would work would coexist without any issues with the current conditions in the city of Spirit Lake. And for that reason, we believe that this application should be approved. I stand for any questions that you have.
I don't have any right now. Thanks, Vlad. Okay, we'll hear from the applicant now. Brad Marshall?
Yeah, please.
Oh, here. Hi, Brad.
Good evening. And this moves my slide.
Yeah.
Do we have anybody on the Zoom call?
I don't know. Let me see. Oh, great. Yes, there's one person besides staff. Oh, I don't know how we lost that. Try the Command P again. Go to duplicate. Right.
That's good. Do you mind if I do a little trial here?
That should go to this computer.
No.
There you
Yeah.
go.
So you have to
Applicants-
click on
The applicant's
middle piece,
presentation
and
will
then you
be
can scroll
HE
back up and down.
1001.
Go ahead, this one, this one.
Go ahead.
It's this computer that you're aiming at.
Yeah. I don't know what I'm thinking.
Sorry, just doesn't work. Just go ahead and click up and down. You're good. Don't click anything else. And you're good.
Okay, here we go. I do a lot of hearings all over the region. You always got to get
Every
adapted
place
to their
is different.
technology. Nice to take my own stuff.
Yeah.
But nonetheless. Again, good evening. I'll be brief. It's
Name and
Brad-
address, please.
Sure. It's Brad Marshall with JEB Engineers, 7825 Middle Arc Way in Coeur d'Alene. Again, it's a pleasure to represent the applicant, which is Dolan Land Management. With me tonight is Jim Dolan with the Dolan family. He's available to speak if needed. Also with me tonight is Tony Vallely. He's a commercial real estate broker who works with the family as well and available to speak if needed. I, again, brought a PowerPoint. We provided it on the record so that I have written hard copies if needed as well, so part of the record. I'm going to kind of zoom through that and be brief as I can. I'm going to take 2 seconds to thank Zach, the prior planner who worked on this project. It was great to work with. Kind of a loss to the county, but we wish him the best. And of course, Vlad, who I worked with for years, and David. Oh, it was good. Little history on the property. It's been in the family for many, many years. God, maybe as many as 50 years. Originally a founding family. We actually tried to annex it to the city of Spirit Lake for it's been a couple years because it's adjacent to the city, and we knocked on their door multiple times, and they graciously or politely said, no, thank you. But we're not opposed to development of your property within the county. So we tried that approach. A little housekeeping too. Again, we reviewed the staff report, absolutely agree, very well written staff report, agree with the findings, particularly the finding at the tail end of the report that speaks of Staff considers the applicant's request appropriate. Again, we've submitted a very detailed and strong application that we believe meets the 11 findings of the county code. And again, I think staff has adopted that. I want to talk a little bit about the site and the surrounding land use. Okay. Why is this? We'll just go for it. There we go. We can kind of move on to the next slide.
Just tell me when you want. So.
Next slide. I'll back up a little bit. Next, go forward. Again, this is the county's comprehensive plan. It designates the area as a border community, as an urban designation, but more intensive uses within that land use. You can move on to the next slide.
No, I'm stuck. That's weird. Oh, the mouse is working, not the button on the.
We can move that. There we go. And as Vlad mentioned, again, the sites within this area city impact, the Cedar Spirit Lake, again, indicator of a more intensive use of the site. Next slide. And again, this is a map that was brought up before, but it's a very important map. This is the future land use map for the city of Spirit Lake. And it's a little bit hard to tell, but if you kind of zoom in on that, it shows kind of a red corridor along Highway 41 on both the east and the west end of the site, and designates a good portion of this as commercial in the city of Spirit Lake's future land use map. Next slide. Again, this is a prior map that's part of the staff report, and Vlad touched on as well. Again, the subject site is delineated. It's got the red boundary around it. Again, there's restricted residential around it to the west and to the south and so forth. But again, a commercial zoning to the east and a commercial zoning designation in the city limits of Spirit Lake, adjacent or just west of the high school. So again, we've got a good band of commercial on both on the east side of the site, very compatible. This is an extension of the same thing. We can move on to the next slide. I'm going to take a little bit and talk a little bit about, remind myself, of kind of the characteristics of the site itself. This is kind of an illustration that we put together into the exhibit that's kind of a cross-section of the elevation differences. So if you look on the right-hand side of the map, that's the center line of Highway 41 where potential commercial use would be. And as you extend over about I think it's actually almost 600 feet to the western property line, there's actually kind of a trough there. That's the old railroad right-of-way. That railroad right-of-way ran into the city of Spirit Lake, and that's where the mill was. Today, that railroad line is removed. My point of that creates a nice buffer between the commercial uses that are likely located adjacent to the highway and the residential uses that tend to be along the lake. And then as you kind of drop in farther, those residential uses along the lake are more than 100 feet in elevation difference between the top of the site and the elevation of the lake. And to kind of give you a perspective, 100 feet, well, it's 100 feet. Well, this is about 75 feet. A typical, you think height, a typical bull pine or a ponderosa tree runs about 80 to 100 feet. So there's a nice elevation difference between where those commercial uses will be in the lake itself and the homes along the lake. Staff also kind of touched on it too. There's some performance standards in the code that require the mitigation of the commercial use to the residential uses are adjacent. One, by nature of a commercial use. The other one is because we're next to a residential zone. So we'll have to address buffering through landscaping, fencing, screening, and land use. So there's techniques to mitigate the impact of that commercial use to the property. We talked a little bit about, actually in a prior hearing, there's a, what's it called, special notice permit. So again, this establishes that commercial zone change, and then as the intended specific use comes along, they'll go through a special notice permit where you submit a site plan. It's routed to the agencies, routed to the adjacent property owners. They look at, it's an engineered site plan, a stamped landscape plan that goes along with that. Again, to make sure it meets the code and mitigates the impact. So it's a pretty well put together use. I also want to take 2 seconds and talk about kind of the, I'll say the environmental concern is that, again, as you're probably well aware, there's different land uses. There's industrial zones that have heavy industrial. There's light industrial zones that have manufacturing inside of a building. This is a commercial zone, which is primarily a retail use. And again, by the health district's regulations, as Vlad mentioned, we're limited to 250 gallons a day, which is a pretty equal to about a house. So by that, the nature of that restriction is limited to a pretty dry use. It's probably maybe a bank with some restrooms, maybe an office building, a vet clinic or a doctor's clinic, something that doesn't produce a lot of wastewater that can be mitigated. Also, there are what are called secondary containment requirements that are required by the health district. So that means one is you have a concrete pad for any kind of hazardous waste or anything like that, and then you have a containment beyond that with curbing. So there's some good protection measures there that require engineered site plans and sign-offs and inspections. You know, it's not yesteryear, it's 2021, and there's some good safeguards in place. You can move on to the next slide. Talk a little bit about access to the site. We do have an approved ITD encroachment permit through, again, the state. It's important to understand that this site is not accessed off what's called Watkins Lane. That's the existing Lakes Highway District Road to the south. This site is accessed directly off Highway 41. So my point to that is we won't be mixing commercial access with residential access. That'll be a nice separation. We talked about it before, but that encroachment permit is a little bit of a generic permit. It basically says, hey, we're going to allow access to the site in this location, but if that commercial use is a significant commercial user and produces a fair amount of traffic, ITD will take a second look at that, require a potential traffic study, at a minimum what's called a trip generation letter, that potentially will require additional improvements to that access. So there's some pretty good safeguards there in regards to that. I want to talk a little bit about water. Again, this site's in the county. The good thing is it does not have access to a public water system. The good thing is it is on the north end of the Rathbun Prairie Aquifer. We've submitted a groundwater study as part of the subdivision application, and I believe as part of this request too. In the nutshell is it's over the aquifer. There's multiple groundwater wells in the immediate area that are high producing wells. So we should have very sufficient water to the system. There's a letter in the record from what's called the Rocky Point Water Association. That's a small water district to the south of the project. Good letter. They're doing their job. They're protecting their water source. My firm designs water systems, so we know the importance of that. But kind of clarification is our site is about 600-700 feet from their well. So there's a significant difference in horizontal and, of course, a vertical difference. And again, there's those safeguards there through the permitting and development process of engineered site plans, secondary containment, this 250-gallon restriction. So really the chance of any type of contamination to that Rocky Point is extremely slim, if not impossible. I mean, it's just, and we see wells and commercial uses throughout the region, throughout the city of Coeur d'Alene, in urban areas under the same circumstances. Again, good letter. They're doing their job, and I applaud them for keeping an eye out on those things. Again, wastewater, we've talked about that a little bit already. Again, restriction of 250 gallons a day, pretty limited uses. You know, another use that might be appropriate on this is just storage, like possibly a limited commercial use with, you know, possibly boat storage or some type of storage facility with a little bit of retail up front. There's a convenience store that's going in on the northeast corner in the city limits, so they kind of tie up the, you know, how many convenience stores do you need at a corner. I'm going to kind of wrap up. It's, it's a long night. Again, we've got a strong application, strong staff report. We've got a PowerPoint that's part of the record. We believe we met the 11 findings of approval. We've indicated that in our submittal. It's very straightforward. Staff has adopted that. The agency comment has been very supportive of the request. Just a few adjacent neighbors with a couple questions and concerns, which are good. And with that, we would respectfully request approval.
Thank you. All right. James Dolan, do you wish to speak?
I really have no comments at this time. Thank you very much.
Okay. And Tony Vallely, in favor, wish to speak?
Briefly, please.
Okay.
Good evening. My name is Tony Vallely. I'm with Keller Williams Commercial Realty. Address is 323 East Front Avenue, Coeur d'Alene, Idaho. And I really just briefly wanted to talk about the market, I guess, real estate market and the saleability of these properties, kind of to give an idea as to what is the best way to market the property, sell the property, and use the property. And what we've done here is we've applied for this commercial use because, as Vlad and Brad have already discussed, really it's probably the best use for this property because of the high traffic volume that a highway-on-highway intersection produces. It is currently the last undeveloped highway-on-highway intersection in Kootenai County, so it's obviously primed for that. And as Brad mentioned, there is a convenience store that will be coming up shortly. We actually brokered the sale of that property as well as the neighboring 5 residential properties that are just north of this property. I bring that up because all of those buyers knew that this was part of what would be happening is an application for a zone change into commercial. There's not a lot of opposition to that because, again, the property just, it fits well as a commercial use. As a 26-year veteran of selling commercial real estate, I think I have a pretty good feel for what the market is like and what buyers and sellers are looking for. I believe that if this were left as just residential, which it currently is, I think it would be a harder sell. I think, as Brad mentioned, it's really tough for a residential use with the amount of traffic and road noise that would be produced specifically at that intersection. So I think by changing the zone, it gives us an opportunity to put the property into a better use and, quite honestly, have a better user. So for the fact of doing something with this property, I think the commercial is probably the best option. I think that's probably about all I have, if there's any questions.
Thank you. Zoom?
We do have one person on Zoom that I'll ask to unmute if they'd like to speak. McVeigh, would you like to participate in this hearing? Again, the person on Zoom that's listed as McVeigh, if you'd like to speak to this issue, unmute yourself at this time. Seems like we could let that one go.
I think so. And the other two are...
Mary's staff and I'm staff.
Okay. All right. Then that concludes our hearing this evening for case number ZON 20-0004. Thank you very much.
Yeah, there were multiple weirdnesses tonight.